Okay, welcome. So, Saturday night, March 13th, and we're going to be talking about what has happened since YouTube nixed my previous two reports on what was going on. So, a lot of you, I suppose, by now have already received your gold nugget. I mean, your gold star. And it's quite a trophy, isn't it? When you're going to be able to prove that you put up a fight against what you consider to be false information. So I'm going to pop over to my blog to start telling you about the articles that I wrote. The important one was YouTube downs COVID federal court resistance videos. So it was called COVID Federal Court Resistance 210222. It was taken down. But it's at Rumble now. So I've uploaded it to Rumble if you want to go see what it's about. Now, unfortunately, Rumble's search engine won't find me. For some reason, none of my videos come up, and Smartest Man Says doesn't come up. Now, other channels come up, but not mine. So I don't know why. But anyway, if you go to my master video index at smartestman.ca/KOTP, King of the Poppers, and I'm talking about poor people poppers, smartestman.ca/KOTP has all my videos, including the Rumble links. So then here's the message I got from YouTube. It said, effective content. This video is now visible only to you and will be removed entirely within 7 days. Because it's the first time your account isn't affected. You're only warned once, and this warning will remain on your channel. If this happens again, your channel will get a community guidelines strike. You won't be able to do things like upload, post, or live stream for a week. Content removed. If you think we made a mistake, you can appeal this decision. Warning on February 24th. So I appealed, and it was rejected. Now, they didn't tell me what was objectionable about it, and they never do. They just say, you're guilty of violating our community guidelines. Our judge has found, without even telling you what the charge was. Now, you can't get more corrupt than that kind of a system where they won't tell you what they found you guilty of as they announce the punishment a week off. Now, my next video, which was 210223, got another strike, got taken down, and now they banned me for a week. So we're back now, and we're not allowed to talk about the medical issues, and we're not allowed to doubt the medical issues. Now, that's the good point. I mean, when YouTube and Facebook and Twitter take down President Trump, that's just affecting election odds. But when they take down medical information that could be true, well, that's killing people. And in some countries, they still got the death penalty. So when the truth finally comes out about whether or not this thing is really as serious as it is, and if they were wrong, we can go to charge them. And that is what I'm going to. Now, I've done this before. I have used the criminal courts to charge people with, well, I charged the governor of the Bank of Canada with mass murder 40 years ago for charging interest, putting farmers out of work in a world that's starving. So, yes, we're allowed to press charges for crimes in Canada, even if the government won't do it, and see what happens. So when this is over, if they made a mistake and they suppressed information, medical information that could have saved lives, we're going to be able to go after the censors. Who knows what kind of punishments we come up with. But at least in countries with the death penalty, the victims' families are going to get a say on what kind of a punishment these censors got who censored the truth and tricked their families to death. Or to lockdown, which still caused deaths. How many millions of deaths have been caused by the lockdowns? And we're going to know whether or not mainstream media had a hand in affecting all those deaths. So if they didn't tell the truth, yeah, we're going to be able to go after them. And won't that be fun someday? Be able to point at Twitter and Facebook and YouTube and say, these people hid the truth about a medical situation and people died. And here are the families of the people who died. What do you want us to do with them? Now, I personally have always been against the death penalty. I think it would be better to stick them in a cage where The victims' families can walk by and look at them, curse them, moan at them, tell them what they did, how they suffered because of what they did. Yeah, I think that's better than, cutting them short, making them stick around and listen to the pleadings of their victims' families. So, anyway, that's another issue, but that's censorship. So they took down 2 of our videos, okay? And anyway, this is not the first time they've taken down videos. I mentioned how in 2013, they took down a 2013 video about 911. And basically, this was about engineering anomalies. I'm an engineer, and I'm saying, hey, jumbo jets can't fly 500 miles an hour through thick sea level air. So I didn't see jumbo jets. So what did I see on 911? And I know that an aluminum tube can't pierce a concrete and steel building and come out the other side. So what did I see with this cartoon character Roadrunner cutout in the in the building with a little aluminum wing slicing through steel girders? That's not real. And finally, the third one was about fire melting steel. That is so stupid, but yet the whole world fell for fire, melted those buildings. 2 plane loads of gasoline melted 3 steel buildings. Wow, and they believed it. They still believe it. And you can't say it ain't true without someone objecting, maybe taking you down. They took me down, and all I did was complain about the engineering anomalies. Now, to be taken down as hate speech, imagine that. Now, who could I be prompting hate against? There's no identifiable protected group, okay? There's no race, there's no creed, there's no religion, there's no color, there's nothing. The only thing I might have created hate at is the engineers who lied or who were bad engineers, and they're not a protected group. So I know that they took me down falsely, and someday I'm going to get them. But anyway, now here's the last important one. Scott Adams said, now this is everywhere. Scott Adams said that, if only Trump had played the tape where he said, not the Nazis, as they were accusing him of saying that fine people on both sides were the Nazis. Well, guess what? He said, I got a target on my back. If only Trump had done this, played the tape that said, I'm, not the Nazis. In the second part, the part they cut out, the part they omitted. And he's right. If Trump had played the part they omitted and said, you guys lied to Biden, I need an apology, he would have won the election. Unfortunately, Scott's idea came too late after the election. But I put out a video called Lift the Charlottesville Nazi Target Off Trumpers' Backs. And YouTube took it down. All right? YouTube took down Lift the Charlottesville Nazi Target Off Trumpers' Backs. And if Trump had seen that video and he had been able to do before the election what Scott says would have won him the election. But YouTube took it down and didn't even tell me. Didn't even issue a strike. Just took down the video that would have won Trump the election if he'd seen how to play the move. And the Tosh professor sees moves that slower people don't. And sadly, the Don's a bright guy, but he missed that move. So anyway, all Republicans did. So anyway, I've done other on that, but the point is the censors are going nuts. But there's an example where they affected the U.S. election by killing a video. Had Trump seen it, he would have won the election, said Scott Adams. And he's right. So anyway, I've now posted that video that they took down at Rumble. So if you want to go see and decide for yourself whether or not, had Trump seen this video, lift the Charlottesville Nazi target off Trumpers' backs, if it would have lifted the Nazi target off Scott Adams' backs and all of the other Trumpers with him. So, and don't forget, because of the lie, they killed the Portland kid. So you can demand that Joe Biden apologize to the Portland kid's mother for getting him killed by lying and cutting out where Trump had said, not the Nazis, the statue people. Nazis are fighting with Antifa. I'm not calling them the good guys on both sides. I'm calling good guys on both sides the statue people. So, YouTube, by taking down my video, making sure Trump didn't see what would have won him the election, as Scott Adams said, too late, but I said on time. Wow, YouTube did take down the most important video of all, and you go see for yourself if it wasn't the most important video. So, that is the censorship we're dealing with. And, of course, now, what are we going to do about them? I don't know, but that's coming up later. I gave notice of defamation already for the 911 hate speech, and I've given notice of defamation for the last two medical ones for our group, our COVID federal court resistance videos. And so anyway, let's go on to the next article I wrote. I said, these are issues to COVID restrictions, case management judge. Now, the Chief Justice was asked by a prothanotary to appoint a case management judge because there were already 10 people who'd signed up. So the judge ordered that there would be a prothanotary, Aileen, who would be the case management judge. Now, she doesn't have the same powers as a regular judge. And in our last two large group actions, with almost 400 plaintiffs, each self-represented plaintiffs, we got a judge to be case management judge. But here he appointed a prothanotary. I don't know why, except it gives us an extra step to go through before we get to the top. Now, don't forget, here we are trying to stop what we think is a genocide of people all around the world by lockdown. And it's the job of Benjamin Wong, the Crown Attorney, to stop us. And it's the job of the courts to stop us and fail to see the statistics we're showing them. Remember, that's a standard cop-out for crooked judges. It looks pretty good, but not enough. I'm not sufficiently shown. I fail to see. Now, says a guy who can keep his eyes closed, right? I fail to see. I have not been sufficiently shown. So this is standard cop-outs when you face them with a great case and they don't want to give it to you. They just say, I don't see it. That's it. Now, what judge wants to sign his name that he doesn't see how they exaggerated the threat by a factor of 100 when the stats are obvious in front of him? So I would think no judge wants to take this case. And I would think even the Crown attorneys aren't happy about being stuck on this, having to defend to keep the mass murder going. So anyway, I wrote a letter to her and I said, she ordered the parties will provide their availability for case management. And so I said, I cannot advise other plaintiffs. Oh, and she's also talking about whether they will agree to be stayed and bound by the decision in my case. Now, I had said it would be persuasive, the decision in my case. But because we change our statements of claim over time and make them better and better and better, later guys got better cases. So why should they be bound by a decision in my weaker case unless the judge allows me to amend to upgrade to the statement of claim of the later guys, like Judge Brown allowed us to do. But in the ongoing DELSC claims for damages, Judge Brown, anytime new facts appeared, they were incorporated in later templates. So anyway, and Judge Brown allowed them to be heard. So I can't advise anybody to be bound by a persuasive decision when there's a good chance later claims will be improved. And I will advise any plaintiffs who can't attend the Zoom call to email their consent to a stay pending the decision on the lead plaintiff, but not to be bound by it. So she basically said, I want everybody to show up here to tell me whether or not you accept to be stayed pending the decision in Turmel and you accept to be bound by it. And I'm saying, well, whoa, the stay I can understand. We offered to do that, but not to be bound by it. And but why does she insist on personal attendance? It doesn't make sense just to say, okay, we accept Turmel as the lead plaintiff. And she also said she wants to talk about the timetable for the Crown's motion to strike. Well, I have no comment on timetables other than to follow the timetables in the rules. The rules say when they file their motion to strike, I have 10 days to file a response. Then they have 4 days to file a reply. Then it goes to the judge. What do we need to discuss here? It's laid out in the rules. So anyway, so I think it's just an extra reason to call us into court. Now, finally I asked her and I said, look, in the past, when we had to file a document in court, it's a real pain in the ass. I didn't say pain in the ass, to have to swear an affidavit that I sent it to them. So under Brown, what we did was we were allowed to send an email to the Crown Attorney with our document, our PDF, and then we'd upload the PDF to the court file. And then we would go to the sent folder in our email, and we would copy the metadata from the email to the Crown Attorney, make a PDF of that, save it as a PDF. Then we would go to the court site and upload the acknowledgement of service, and we would upload the PDF proof that we emailed it to him. And then we had to add a third step, which was write a letter to Judge Brown to say, would you please accept the metadata PDF instead of an affidavit of service notarized by a lawyer? And he always said yes. So we had that way of speeding stuff up, making it cheaper so we don't have to pay a lawyer to swear an affidavit that we emailed it when we got the proof in the metadata. So yeah, Judge Brown was extremely reasonable in making everything work. So anyway, that's what I asked her to do. I said, I'd like to do the same thing, be able to upload the document, be able to upload the metadata as the affidavit of service acknowledgement, and without asking you to okay every single one. And that's the only difference. I don't want you having to do all the work that Judge Brown did of having to okay every motion. So anyway, then I told the people who were the other 10 people who'd been called to the thing, I said, if you aren't interested in participating in the admin stuff, just send an email back to the court. And the address is in the heading, saying, any day is fine with you for a hearing, but you shall not attend, but do consent to the lead plaintiff being appointed and having your action stayed, but not bound by it if you get a copy of the documentation emailed to you. So they're willing to give up being served officially in their own capacity and sit back and wait to see what happens to me, as long as they get a copy of all the documents in my fight. So, and they should also consent to other procedural matters. So anyway, after I'd sent that out, she writes another direction and says to these 10 people, further to the court's direction, the court expects that all plaintiffs will participate in the upcoming case management conference. The court will not accept the delivery of a party's position by letter or by proxy. The court therefore awaits the plaintiff's availability for the case conference. And I said, so anyway, so the purpose is, of course, whether the parties consent to me being the lead file and the timetables for the Crown's motion. Now, I said agreeing to the math expert being lead plaintiff and being stayed pending that is fine, but be bound. And things change and later claims may be improved. So by tomorrow, the COVID-resistant 10 must email the court whether they're available to personally attend the call. Now, note, because top 10 are filed in Toronto, Montreal, Vancouver, our list has plaintiffs in 6 provinces and 7 courthouses so far. Now, that's out of all of them, out of all 60. But now this is the first 10 we're dealing with. So I've already mentioned how the discussion of the timetables, I have nothing to say. It wasted time. It's in the rules. The rules say that, they give us the dates and all we got to do is follow it. So she wants everyone to attend a discussion about 2 timelines for stuff that's already in the rules. What do you expect anyone, including me, to say about the timetables? Nothing. So it's a complete waste of time to put those issues down on the agenda, but it sure packed the agenda. Instead of just being, do you want Turmel as lead plaintiff? There were other things to discuss. Oh, the timetables. Well, I could have discussed that and said I got nothing to say. But no, she wants everybody to come and say they got nothing to say. So anyway, I thought it was reasonable. Now, also, I mentioned that the Crown is already in default. They didn't file a statement of claim with a statement of defense within 30 days. Therefore, I can move for a default judgment. But I got to give 14 days notice. Last time I pulled that stunt, they managed to get it dealt with and put out and continue on. And they probably would again. But still, I could if I had to, if they really wanted to waste a lot of time. So anyway, now, the thing about the having to show up, what's she going to do with the next 50 people, right? These 10, she insisted they show up for a hearing on whether they want me as a lead plaintiff and to be bound or not by me, and if they have any comment on the timetables. So if she insists that the first 10 all have to show up for a personal appearance on whether they want me or not, wouldn't the next 50 also have to show up in a personal appearance to decide whether they want me as lead plaintiff or not? Did she think of that? That by making these 10 show up, she was now going to have to make the other 50 show up? Whoa, didn't think about that, did you? So anyway, that's and none of the issues I raised were on the agenda, okay? I said, hey, I want them to send out the documentation to everybody if they don't want to have to serve everybody, right? And I said, so anyway, let's see. And I said, or give me the list of emails and I'll do it, though I don't want to. And so stay tuned. Okay, so the next article on March the 5th was the merger of the latest 40 C-19 plaintiffs with the first 10. So the Crown is trying to fix the case management judge's bad decision to have a Zoom call about okaying Turmel as lead plaintiff and forcing personal attendance of all. Now she'll have to do the same for all the newbies. So the Crown has another 40 plaintiffs they want merged with the original first 10. And everyone but the first 10 and me should have received this letter. And he sent the letter I'm writing on behalf. The above noted claims are virtually identical. Canada therefore requests any file designated as lead among those also be designated as lead among these. Why? Without asking them personally? But the case management judge wants to hear whether they accept Turmel from the plaintiffs personally. May not be good enough to assume all future people accept Turmel as lead plaintiff without their personal say-so. Why would she make the first 10 say so and not the rest? So Canada also requests that these claims be held in abeyance and that they be bound by any determination in the lead file. And again, always pushing for more than's due. Sure, let them be in abeyance, but I've already argued they should not be bound. And he's still pushing for it. And then he gave a list of all the 40 other people. Now, in the original letter that was dealt with the 10 people, they included all the emails. So I got those first 10 emails. But here, they don't include the emails. So I don't know how to get in contact with the other 40. So I got to ask. So I said, notice he didn't put the email addresses like the previous documents. So how can we know they're right, the addresses? Anyway, I'm asking for the list, so it may not matter if he wants to hide them from me right now. Just like with the 400 plaintiff MedPod groups, I had no way of contacting them to make sure they were apprised, and I don't think many were. So there's a new C19 intro page at smartestman.ca/C19, which basically leads to all the documents and the list of everything, okay? I've started a new Facebook page for the public to read updates, where I post all my updates. So Facebook would not let me name any page with COVID. Imagine that. Federal court resistance? No. After several tries, I gave up and I tried Turmel resistance. That made it. So all my reports will be posted there. Next article, May 5th. No security needed for plaintiffs. Now, I've heard some people were wondering if the Crown's request for security is meant for them. Remember, originally the Crown said, we want to have security for people who have existing costs orders against them. So I said, it's not for you if you don't have a cost order. You'll remember in my report on the Crown's February 11th letter, Canada will also seek orders that the plaintiffs with unpaid costs awards provide security for costs prior to the proceeding. So I commented, that's aimed at my brother Ray, who owes some court cost judgments unpaid as yet that prevented another of his actions from going forward. So they're trying again. So if you do not have an unpaid costs award, like my brother Ray, you are not one of the plaintiffs with an unpaid costs award. And no plaintiff who did nothing more than wait to see what happened to the lead plaintiff got hit with costs. Only the lead plaintiff. So I responded to the case management judge on February 15th. The defendant notes some plaintiffs have previous unpaid judgments and asked that security be posted. Considering the no cash cost of emailing out a copy of the documentation after the first case is decided, those plaintiffs could then decide if it's worth putting up security. So if I win, sure, they'll put up security. And if I lose, well, then they can quit without putting up security. So it only applies to anyone who did a template with me in previous cases and went higher to get hit with costs. My brother Ray is the only plaintiff I can think of, and Igor Majajko, but his case is still on its way to the Supreme Court, so you can't call his unpaid yet. So if you don't have any unpaid costs judgments, it does not apply to you. It was purely a shot to inconvenience my brother. On March the 8th, March 11th, 12 p.m. Zoom hearing for the first 10 COVID plaintiffs. So high noon will be held an original Zoom meeting, and it seems like a waste of time since I don't have any suggestions, and neither does anyone else. So anyway, I've heard one person won't be able to attend, so I'm wondering if when they have a hearing for the next 40, why can't he attend their hearing? So, as a matter of fact, he couldn't attend, and I'll talk about that on the next post. So, since no one has anything to say about timetables for the Crown's motions, she'll probably spend her time asking each plaintiff about accepting the lead. And remember, DVD recordings are available from the registry for about $15. So you're not supposed to tape record federal court actions when you can get the DVD for $15. And you certainly can't broadcast it even if you did tape record it for your own notes. Remember that. You cannot broadcast these hearings. So the first COVID federal court Zoom hearing report, and that happened on the 11th. And on the 12th, I wrote, the event, high noon on Thursday, March 11th, was a Zoom audio hearing before our case management judge, CMJ from now on, Her Worship Prothonotary Aylin, Benjamin Wong for Majesty. Reasons. The hearing was for the first 10 about whether they accepted me as lead plaintiff and to have their actions stayed pending resolution of mine, and then be bound by it. I'd objected to her being bound in case they had later updated amended claims better than mine. Lead plaintiff. Problems arose quickly, so the question of me being lead plaintiff wasn't even raised. Some things we wanted, we got, and some we didn't. The jurisdiction. Now, dealing with my concern about the jurisdiction of a prothonotary raised to the Chief Justice to deal with some of our issues. She said that if there's an issue she could not deal with, she'd pass it along to the right level. Okay, good answer. Injunctions. I pointed out prothonotaries do not have the power to issue injunctions, which we're asking for to prohibit COVID restrictions. Is it different that the Crown isn't asking for an injunction, but to strike our asking? Yes, she can strike an action. She can strike an action for injunction, even if she can't grant it. But that can then be appealed to a judge before regular appeals. An extra step to the top. So it used to be if a judge said something, we went to the Court of Appeal and the Supreme Court. Now, if she says something, we go see a judge, then the Court of Appeal, then the Supreme Court. An extra level. Default. Then I wondered why the Crown had delayed filing their motion. I pointed out they were already in default of filing their statement of defense. And CMJ Aylin pointed out she could grant an extension of time after the strike motion. I pointed out that if it was going to take too long, I could move for default judgment. She pointed out once it's in case management, it takes leave. Okay, I could ask. And then the denial can be appealed to a judge. Stays. Then whether the other motions should be stayed pending the resolution of mine. I noted that those stayed should not be bound by my decision, and future plaintiffs had filed upgraded amended claims. And she agreed it would be persuasive, but they would not be bound by my decision. Good. Being kept apprised. Then we got into my request that if the Crown was given dispensation from serving the other plaintiffs and only had to serve paperwork on me, could they at least email a copy of the documentation to the others? They don't have to serve. CMJ Aylin asked if the Crown would consent to email everyone, and Wong said he didn't want to. He pointed out that in the last group action for damages due to permit processing delays, there was no provision made to keep the others informed while the lead plaintiff's case moved on. I responded, I didn't want that happening again. Now, back in 2014, Phelan J, in that group of 400, had no lead plaintiff. So back in 2014, the first group action to get their exemptions back after a judge had cut off half based on the date of their permit, no one was stayed, and the Crown's motion to dismiss served on everyone and heard by teleconference at the April 29, 2014 big event in 10 provinces in 12 cities that have registry. We're now at 6 provinces in 7 cities. It's kind of sad no one from Eastern Canada have filed, despite them being the majority last time. Eventually, all actions were dismissed with no costs by Justice Phelan. Only those who appealed later got hit with Court of Appeal costs. It was $500 about. And most could not and did not pay. After all, after having to shut down their grows and start buying on the white and black markets again, what patients had any extra money? And the Crown didn't want to chase a bunch of broken patients. Convenience for convenience, inconvenience for inconvenience. If the Crown didn't want to be inconvenienced by serving their motion on everyone, the least they should do is email a copy to those who volunteer to have their actions stayed to save the Crown the time and expense. But CMJ Aylin said no. She could not impose such an unwanted burden on the Crown as unofficially keeping them informed, while she considered absolving them of the unwanted burden of serving everyone, which would then have kept everyone officially informed. I pointed out it was extremely easy to mail out copies, given they have a list of the emails, and I do not. But they didn't want to, and she said, I can't force them. So, I said if others were not to be kept apprised of developments in my case, the others should refuse to consent to their stay. We were all there. Remember now, with Phelan, nobody had a stay. They all attended, and the Crown had to file, all of them, their own case, their own motion. They all got a copy of a Gold Star. We were all there in the first group action with no problem, except the Crown had to serve everyone. And I was ready to make it easy on them. Imagine. But the second time around, that was easy on them. They only had to serve the lead plaintiff. But the first time, they had to serve everybody. So now he's saying, hey, we didn't keep anybody in the second case apprised. And that's why I'm saying, don't agree to a stay so you can be like the first case where they got to give everybody an official motion. So it was up to the Crown if he wanted to inconvenience us. We'd inconvenience him back. She said it wasn't an issue of making it inconvenient, and a prothonotary had the power to stay the other cases without their consent anyway. I added we could appeal to a judge. Hope she doesn't. But I advised her that if Wong didn't want to send them a copy, I'd have to advise them not to consent to being stayed and remain involved to get their own documentation with their own name on it, too. Nice souvenir. 2 gold stars on the wall. And an order, a decision, another 3rd gold star on the wall. So, as for the lead list, I had asked for the list of emails so I could keep others informed. The Crown's regular complaint was that he didn't want me representing the others like a lawyer, as if making the arguments that will eventually impact other decisions isn't the same. The judge didn't like providing me with the emails because of privacy concerns. I pointed out they'd included the emails of the original 10 in the direction calling the hearing, so why couldn't I get the emails for the others too? Nope. Barb Kelly listened in on a hearing, though she wasn't one of the original 10, and then sent me an email noting that in the March 4th direction to the other 40 plaintiffs, their emails were in the message header metadata. And it said, okay, emails from claims. But CMJ Aylen said I could have copies of the filed statement of claim with the emails on them so I could build my own list of plaintiffs and keep them informed myself after her decision cuts them off. Doable by me and fixed. So, as long as I'm going to get a copy of the statements of claim, I can build a list of emails. Doesn't matter, though. The Crown doesn't want to make it easy on people, so people should stick around and get their own personalized copies of everything. Now, stay poll. So the judge started asking each plaintiff what they wanted to do. A few said they would accept the stay. A few said they would not. And a few asked for more time to think about it. The judge gave them until March 18th to inform the court of their decision on being stayed, until March 24th for the Crown response, and March 29th for the plaintiff reply. She also noted that anyone could change their mind. That was nice. Security for costs. Although the direction doesn't mention rejecting the Crown motion for security for costs for those who had prior cost judgments, my brother Ray, CMJ Aylen did ask the Crown how many there were. He didn't admit it was only Ray, but did admit it was very few. So the judge said she'd take it up after my case was done, which is what I'd asked for. Let Ray decide if he wants to post security once he finds out what happened to me. Obviously, if I win, he will want to. Now we got into the metadata for proof of service. I had asked to allow the substitution of the email metadata, to, from, date, title, as Justice Brown had allowed, but without her having to okay each document. Sure, it's easy for the Crown to get a document notarized by another lawyer, an affidavit of service, at the next desk, but not so easy for self-represented plaintiff. With Justice Brown, a method to save us that pain and expense arose. I'd email it to the Crown, make a PDF of the sent file, upload the document, upload the sent metadata as proof of service, and then upload a letter to Brown to accept the metadata in lieu of notarized affidavit, which he always accepted. Judge Brown is the most logical judge I've ever run into. Sure, I'm biased. He gave us 2 wins before higher, slower judges took them away. But no, what may have been good enough for a full judge wasn't good enough for a temporary one. So she refused to allow us to use the metadata. She wants us to have a notarized affidavit submission to prove that we emailed it to them. So we have to go to a lawyer or go to a notary and say, I swear that I sent the email to the Crown. That she will accept, but she won't accept the metadata like Judge Brown would. So the metadata was good enough for a real judge, but not good enough for a temporary one. So the registry clerks all may commission an oath for free, which is what I've always done in the past. As I hate paying a lawyer to do something I consider pretty useless, why not make it an offense to lie in any court document, not just those where it's sworn to be true? So I asked what I'm supposed to do in these times of COVID. She said it is now acceptable to use whatever COVID procedure was used by courts of my own provincial courts. And I wondered if the federal court had such a procedure for their clerks. She thought so, but wasn't sure. So I'll find out. I don't think they do. Direction. I should have found out by now. Let me make a note here, okay? Commissioner, Fed Court Commissioner. I'll find out if there is some way to do it and let you know. Mind you, you're not going to be doing any motions, only I will right now. Unless you need some kind of special interim exemption from a curfew in your town. Then you can probably ask for leave. So then, late in the afternoon, she issued a direction. A case management conference was held today in these 10 related files. The plaintiffs 219 and 221 were not in attendance. As was made clear in my earlier direction, all parties are required to attend all case management conferences. Any future failure to do so may result in cost consequences or the dismissal of your proceeding. So, she's talking about the two plaintiffs I know who can now ask that they be allowed to attend the upcoming hearing for the next 40 plaintiffs being asked whether they too accept the lead plaintiff or accept the stay. So if CMJ Aylen dismisses them over not personally attending, once she indicated she would not accept the answer by email, for sure they'll have to appeal to a judge. And won't splitting us up make things interesting? So the courts proposed that these files be stayed pursuant to Section 50, pending the final determination in my claim. Following the determination in 130, which includes any appeals therefrom, she's saying this, a plaintiff would then be entitled to request that the stay of the proceeding be lifted on the basis that they are differentially situated in Mr. Turmel. That's right, if something is better. Unless the judge allows me to update something over time. In the case of a stay, the court would not obligate the Crown or Mr. Turmel to serve a plaintiff with any documents related to T-13021. So if there's a stay, she's not going to make us send them anything. Got it? So if you agree to be stayed, you get nothing. You're going to find out at the end of it all whether you're still involved or whether you're dead, but you won't know what killed you. So that's what we wanted, because more and more good news is arising that we may want to add. So all those doctors protesting around the world, all those lockdowns being lifted would surely be relevant to our actions, and we can include them later. The court requires that any plaintiff in this group of 10 files who does not consent to a stay of their action has to file by March 18th, response by and then final reply by the March 29th. So I wrote the Crown blew it. I have to advise not to make it easy on the Crown and make him serve each and every one of us our own document, like the plaintiffs in the first group before Justice Phelan, with no lead plaintiff. He could have had it easy with the simple expedient of emailing you a carbon copy when he emails me. Nope, he had to go for convenience for him, but not for us. And now it's going to cost him. I tried to make it easy on him if he would only take an easy step to make it easy on us, but no. And now he's faced with the same situation as before Judge Phelan. Everyone gets an official copy, and everyone gets to offend an official big event. So buying a recording. I emailed the clerk to order a DVD recording. I bet others recorded it. I can see it for their own personal notes, but not for broadcast. Get it? Broadcast would get anyone in trouble, even me with my official DVD version. Now, in over 40 years of legal and political activity, I have not had to lie in any official capacity, nor left myself in a position to be caught. So if they asked me if I taped it, I'd have to admit the truth. So I don't leave any chinks in my armor. I wanted to, but I did not tape it. I'm working from my written notes until I get a copy of the audio I ordered today. Now, I'm quite proud of being the first person I know who regularly taped all my Ontario court appearances since 1988, when I found out it was allowed, except almost no one knew the rules had been changed. I could, but only for my own personal notes, which means that I can now transcribe my personal notes perfectly, right? I even have the whole Hitzig appeal on tape. This is like 5 days before the Ontario Court of Appeal, 3 judges, and then transcribed and posted it all. Having taped notes sure made my reports unassailable, right? So I actually pity both Crown Wong and CMJ Aylan. We're asking to put an end to a murderous lockdown, and they have to put their names on keeping the genocide going. Posterity will not be kind to those who failed to see the blood in the streets. So YouTube live stream Saturday night where I announced this one here and where my channel is. Now, what's interesting, if you want to find my videos, you have to go to my video index. If you go to Rumble and you search for Smartest Man Says, I don't come up. If you search for Mark Dice or anybody else, they will come up and their videos, but not mine. And if you search for Lift the Charlottesville Nazi Target, I won't come up. But if you search for the title of another guy's video, it will come up. So I'm saying the Deep Swamp is still censoring me, even at Rumble. Okay, so isn't that neat? So people are escaping YouTube to Rumble, where, mind you, they only censored, well, they're censoring me, no one else as far as I know. So, and why me? Because I'm doing the stuff that really hurts. So that's the last article I wrote. And so now we're at, that was the Rumble. And now I'm going to go back to my video here and see. Okay, so anyway, that's basically an update of everything that's happened so far. And now we're going to have the people decide by next week whether or not they want their actions stayed or whether they want to participate to the end, like under Phelan. So remember, under Phelan, you had like 300-400 people at this hearing, this big event, and huge event. The Crown said this is unprecedented, extraordinary, remarkable to be in 10 provinces and 12 courthouses, even though we're not there yet. But we could be soon enough. And it looks like they're stalling stuff, okay? So we always, even if they do strike the claim, we now go to a judge before we have to go to the higher levels. So they've added a lot of time for a lot of extra blood in the streets, and that's going to be on their tab, okay? That this added time that they slowed it down by going pro notary instead of straight to a judge. So anyway, that's where we are right now, and let's see if this one gets banned, okay? But I don't think so. We didn't do any talk about, any medical talk. We only talked about legal talk and what was going on. So at this stage, by the end of the month, we should have her response on what's going to happen. But if nobody agrees to be stayed, or very, very few agree to be stayed, and most, what's she going to do for the next 40 people, right? What's she going to do? You got those. She can't say, I'm going to apply my decision for the first 10 to you. She has to ask everybody. Isn't that funny? So, and now we're up to 60, over 60. So it's going to keep growing. And I advise you, if you have got your gold star, show it around. Tell your friends how easy it is to get for a lousy $2. Proof that you resisted in the official resistance in the federal court. And it's one hell of a... And of course, if you don't stay, then you're going to get 2 more gold stars. You're going to get the motion with the Crown's thing on it. And then you're going to get the order, the decision on it. So, and who knows what else happens later. Anyway, so if you want your trophies on the wall, stick around for one hell of a fight.